Yeah, back at it again.
We will hear first from appellant, Mr. Fry. Mr. Fry, do you want to reserve any time?
2 minutes, Your Honor.
Very well. And don't hesitate to correct me if I'm pronouncing your name wrong.
Fry is correct. Thank you. My name is Richard Fry. I'm here on behalf of the plaintiff and appellant, the California Business and Industrial Alliance. I may refer to them as CABIA from time to time. This is a case of first impression in California. The Private Attorney General's Act does not create a private right of action. A PAGA plaintiff cannot seek recovery of personal damages such as lost wages or emotional distress. As stated by virtually every case to consider a Private Attorney General's Act case, a claim, it is fundamentally a law enforcement action that substitutes for an action brought by the government itself. The question presented in CABIA's lawsuit is whether the California legislature can deputize private attorneys general to seek civil penalties for violations of California law. Or, to use the language in the Supreme Court case Marine Forests, the question is whether PAGA's statutory provisions as a whole, and when viewed from a realistic and practical perspective, intrude on powers that the California Constitution expressly delegates to the executive branch. This is a question of first impression in California. The Supreme Court in Iskanian did not consider it. However, in the more recent case, Abbott versus State, the Supreme Court did touch upon it, and I think it's very important, and I'll explain that later. The parties have thoroughly briefed the sufficient control standard in Morrison and in Kelly. We've also explained the absence of any mechanisms of control in the PAGA statute. In preparing for today's hearing and in reviewing the applicable authorities, it became increasingly unclear to me that we can show that PAGA violates California's separation of powers doctrine simply by referring to the plain language of the Constitution and the PAGA statute itself. At the outset, I want to acknowledge that there is a fundamental difference between the California and U.S. Constitution with regard to the strength of the respective legislatures. Whereas the United States Congress's powers are limited to those granted by the U.S. Constitution, the California legislature has the power to exercise all powers not forbidden by the California Constitution or, importantly, delegated to the general government. As the California Supreme Court explained in Marine Forests, it is well established that the California legislature possesses plenary legislative authority except as specifically limited by the California Constitution. Several provisions in the California Constitution demonstrate that it specifically limits the legislature's authority to hand off the executive branch's law enforcement powers to a private army of non-executive branch, non-governmental actors to enforce labor law violations. None of these provisions were considered in Iskanian. First, Article 3, Section 3 of the Constitution. The powers of the state government are legislative, executive, and judicial. Persons charged with the exercise of one power may not exercise either of the others except as permitted by the Constitution. This is the separation of powers doctrine under California law. Second, and this is most critical, Article 5, Section 13 establishes the Attorney General as the chief law enforcement officer of the state. It's important. The U.S. Constitution doesn't have a similar definition. The Attorney General, an elected public official, is described in detail what his or her duties are. There are 4 express powers in that definition, and I'd like to read for you the definition because I think it's that important. Subject to the powers and duties of the governor. 1, the Attorney General shall be the chief law officer of the state. 2, it shall be the duty of the Attorney General to see that the laws of the state are uniformly and adequately enforced. 3, the Attorney General shall have direct supervision over every district attorney and sheriff and over such other law enforcement officers, this is really important, such other law enforcement officers as may be designated by law in all matters pertaining to the duties of their respective offices. That's the third. The fourth power. Whenever, in the opinion of the Attorney General, any law of the state is not being adequately enforced in any county, it shall be the duty of the Attorney General to prosecute any violation of the law. In the Superior Court, it's not that relevant here, but that's a fourth power. Article 5 creates a hierarchical structure that should not be surprising, since the California Constitution is based on the U.S. Constitution. Section 1 of Article 5 states that the governor shall see that the law is faithfully executed. And as I just described, Section 13 establishes the AG as the chief law officer of the state, subject only to the powers of the governor. Importantly, Section 13 further mandates that the Attorney General directly supervise every district attorney, sheriff, and such other law enforcement officers as may be designated by law in all matters pertaining to the duties of their respective offices. These are public officials. They're not private citizens. While the legislature has power to designate certain law officers within the executive branch, it is the Attorney General's exclusive duty to supervise them. The legislature does not have any supervisory role. It is clear that these law enforcement officers must be public officials rather than private citizens, based on the use of the term officer and the remaining clause in all matters pertaining to the duties of their respective offices. Under this framework, the Constitution provides for the Attorney General to exercise his or her law enforcement powers subject to the powers only of the governor, and for lower law enforcement officers to serve under the supervision of the Attorney General. By establishing this hierarchy, the Constitution places all law enforcement powers squarely within the executive branch's core constitutional functions.
In these PAGA cases, isn't the Attorney General given notice of what's going on at various times during the proceedings?
The answer is definitively no. The Private Attorney General's Act only requires that a limited notice be provided to the Labor Workforce Development Agency. There is no obligation for the LWDA, as I will refer to it, to even review the notice, much less report to the Attorney General or seek any guidance on whether to prosecute that action or not. Our briefs go into detail.
And what's the association between the Attorney General and the LWDA?
They're both the Attorney General's at the top of the executive branch. The LWDA would be further down in the executive branch under the Department of Industrial Relations, but they're both executive branch agencies.
Is there some reason for us to infer that there's no communication between the two?
No, you don't need to. 99% of the notices, admittedly, are not even reviewed by the LWDA. So for the Attorney General to suggest that the Attorney General is reviewing these notices would be absurd.
Mr. Fry, aren't all powers not enumerated reserved to the people?
Reserved to who?
The people?
Yes. The people being the legislature?
The people being the people.
That's an interesting question. I mean, it's reserved to the legislature when you're talking about making laws.
Okay.
And yeah, the people do have powers, but individual private citizens don't have the power to act as police officers or the power to enforce state law. That's the critical comparison. And when I get to the Abbott decision, you'll see exactly why. The AG argued exactly that in the Abbott case.
So is it your position that all key TAM statutes are unconstitutional?
They're certainly subject to this control standard, and if there's sufficient control, I believe they could be constitutional. But the statute I'm challenging, that CABIA is challenging, the Private Attorney General's Act, falls well below any of the traditional key TAM statutes. The notice provision is a sham. There's no control. There's no right of intervention. There's no ability for the state AG to intervene. There's no ability for the Labor Workforce Development Agency to intervene. I don't dispute, I don't dispute that the Labor Workforce Development Agency can't be assigned the power by the legislature to review the notices. That's covered in section 13, and we'll get to that when we get to Abbott. They have the power to move enforcement power around within the executive branch. That's the problem with the whole statute, is it takes power from outside of the executive branch and hands it off to private citizens, none of whom answer to the people who elect, none of whom answer to the people who vote. The governor, the AG, the officers in the executive branch that are the law enforcement officials, they answer back to the public. Here, conveniently enough, there's no answer. And that's why we've had a terrible situation with PAGA. And I'm not going to get into that. I don't know that it's relevant to this challenge, but there's a reason so many people are frustrated with this. You have private citizens running around with state power and abusing it, and they don't have to answer to anybody. So despite the clear language in Article 5, the Attorney General has argued in this case that his power is limited to criminal matters, and that the grant of authority in Section 13 is somehow general, whatever that means. Yet during the pendency of this case, and this is important, we had filed our lawsuit already, and this Abbott case comes up. During the pendency of this case, the Attorney General argued that Section 13 applied to California's unfair competition statute. That's a civil statute where they seek civil penalties. They argued not only that it applied, but that somehow it foreclosed public law enforcement officials such as district attorneys. It foreclosed them from seeking a remedy on behalf of the state. So they sought an expansive definition of Section 13. But Section 13 allows that. Section 13 allows the legislature to allocate the enforcement power to a district attorney, as long as they don't disrupt the ability of the AG to supervise the district attorney. But this AG argued the other side of that. Dishonesty is one word, hypocrisy is another. None of it really matters. The reality is Abbott correctly ruled that Section 13 defines the AG's constitutional role as chief and law enforcement officer. There's been another suggestion that there's not a core function of being the chief law enforcement officer. Again, they don't teach civics that often in school anymore, but back when I was going to school, you learned pretty clearly that the executive branch is the branch that enforces the laws. The judiciary interprets the laws. The legislature writes the laws, and in this state, does the budget. But they don't enforce the law.
But if you're making a separation of powers argument, and those are the three branches of government, and the people are enforcing the law, to quote you, how is that a separation problem?
The people, so if what you mean is a private citizen is suing to enforce their rights, but that's not what's happening here. The private citizen is bringing a claim on behalf of the state.
Right.
They're not bringing a claim on behalf of themselves. That's why I started this with, it's not a private right of action. It is literally the handoff of a state enforcement action to a private citizen.
But the way I understand separation of powers is you have two branches of government that are somehow in conflict with each other.
Sorry, I can't see because of the
It's
mask.
me.
I apologize.
It's okay. I should raise my hand.
No problem.
So the way I understand separation of powers is it's two branches of government that are at odds with each other.
Right, so
in this
here-
case,
oh, sorry.
you're saying the people are at odds with the executive.
I'm saying the executive. It's surprising to me, let's put it this way, that the Attorney General isn't on my side of the V in this case. The power that's being taken is the executive branch power. It's being handed to private citizens unchecked. And we do talk about substantial control. We do cite cases that if you got to that test, that PAGA doesn't even come close to meeting it. But the clear role here is, and by the way, Marine Forest says some interesting things. It says there are three branches of government. There isn't a fourth branch. So this notion of a public bringing a branch is just not there. There are three branches. They each have specified powers, and they're not to intrude on one another. And just let me get to Abbott. This is a very important case.
We've used 14 of your 13 minutes.
I apologize.
Do it quickly.
In Abbott, the Attorney General argued that his role was so broad that he could foreclose a district attorney, a public officer, from bringing a claim on behalf of the state. The Supreme Court correctly ruled that that's just wrong. And an important statement that the Supreme Court said, and this can be found at pages 659 and 660 of the decision. I urge everybody to read it and to understand that to the extent somebody believes they're covered by Ascanian, which again I'll deal with on rebuttal if I need to, Abbott is a new Supreme Court decision setting this forth. The court says, in reading the language of the constitutional provisions concerning the role of the Attorney General and district attorneys, we find nothing in those provisions that constrains the legislature's prerogative to structure UCL, unfair competition, to structure UCL enforcement so that a district attorney has authority to seek civil penalties and restitution for violations outside of his or her county. That's in Section 13. They have that power subject to law, it says in Section 13. Key sentence. The UCL does not undermine the Attorney General's constitutional role as California's chief law enforcement officer. In particular, the public enforcement authority that the UCL grants to the district attorneys does not constrain the Attorney General's prerogative to intervene or take control of a civil enforcement action that, in the Attorney General's view, does not adequately serve the public interest. And what they're saying is, because the public servants within the executive branch all serve the AG, the AG has the ability to intervene. When you take a group of people, private citizens, they're not covered by Section 13. There's no such thing as a private citizen army under our Constitution. There's no citizens get to enforce the law provision under California law. When you take such a thing, the AG now loses the power to control. And that's what Abbott stands for.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Aaron
You
Jones.
can take off your mask if you'd like.
Thank you, yes. Good afternoon, Your Honors. Aaron Jones for the respondent. Your Honors, plaintiff's separation of powers claim in this case lacks merit. The claim cannot be squared with the ruling of the California Supreme Court in Ascanian v. CLS Transportation. But even absent the Ascanian decision, PAGA would raise no separation of powers problems. And I'd like to briefly address both of those points this afternoon. First, counsel did not address the Ascanian decision, but as we've explained in our papers, Ascanian squarely, the reasoning of the Ascanian opinion forecloses plaintiff's claim in this case. In Ascanian, the Supreme Court squarely ruled that public prosecutors need not maintain supervision and control over PAGA cases, PAGA plaintiffs. In Ascanian, the plaintiffs had attempted to apply the rule of an earlier case, County of Santa Clara v. Superior Court, to PAGA. In that earlier case, the Supreme Court had ruled that when the government, prosecutors, engage private counsel, or at least financially interested contingency counsel, to litigate certain civil enforcement actions on behalf of the public prosecutors must supervise or control the outside counsel, the private counsel, to ensure notions of prosecutorial neutrality and the like. And in Ascanian, that the plaintiffs attempted to apply that rule to PAGA, and the court squarely rejected the claim and ruled that the state need not have that kind of supervision and control over PAGA cases. And plaintiffs cannot meaningfully distinguish that ruling here. In their reply brief, plaintiffs have now said that, well, they're not arguing that the state actually has to maintain supervision and control over PAGA cases, only that there must be sufficient mechanisms of control in the statute, but that is a tenuous distinction at best, and it's one that plaintiffs' own arguments in this case have not maintained. Plaintiffs' opening brief is littered with arguments that the problem with PAGA allegedly is that it does not require the state to oversee and control PAGA plaintiffs in various ways, such as that it does not require the state to review and investigate PAGA notices. It certainly permits it, but the opening brief said the problem here is it does not require that sort of oversight and control. So this distinction is not a viable one. Iskanian squarely ruled that the legislature can, quote, enlist willing citizens in the task of civil enforcement, unquote, without violating separation of powers. And that ruling should control here. But, Your Honors, even absent the Iskanian decision, plaintiffs' claim would lack merit. A measure violates separation of powers, as I believe both sides agree, only if it defeats or materially impairs core constitutional functions of another branch. And here plaintiffs allege that PAGA interferes with the executive branch's constitutional functions, relying predominantly on the Attorney General's functions under Article 5, Section 13. But plaintiff does not and cannot show that PAGA interferes with the Attorney General's constitutional functions under that provision or any other constitutional function of the executive. As we explained in our papers, Your Honors, the courts are clear that Article 5, Section 13 is focused on criminal enforcement, and it does not provide that any particular civil enforcement action or mechanism is a core or inherent or exclusive function of the executive. And the courts have repeatedly made that clear. While the Attorney General certainly has broad authority to pursue civil actions in the public interest, the courts have been clear that that authority is not free of legislative restriction. And indeed, we provided examples of statutory schemes that limited, in some cases substantially limited or virtually supplanted the Attorney General's traditional enforcement powers over particular issues or statutory schemes. And those enactments have been upheld. Therefore, plaintiffs cannot ground this claim in Article 5, Section 13, which is their primary alleged source for this conflict with executive functions. And plaintiffs have provided no authority whatsoever that PAGA could be deemed to interfere with any other constitutional role of the executive branch, despite sort of fleeting references to other provisions. Counsel argued that the separation of powers provision itself might somehow be relevant, but the separation of powers provision does not vest substantive functions in any particular branch. That's axiomatic from the case law. Plaintiff also cannot sustain a claim simply by referring to enforcement of PAGA actions generally as an executive function. Counsel has conceded here that for there to be a separation of powers issue, there must be a conflict with an express constitutional function of another branch. And simply labeling a matter an executive in nature does not identify any core constitutional function. And indeed, as we outlined in the papers, there have been instances where civil enforcement authority and prosecutorial discretion over various civil enforcement matters has been completely taken outside of the executive branch. And, for example, the courts and the legislature and members of the public have been given control over prosecutorial discretion over civil enforcement matters. And I'm referring to, for example, In re MC and the Gananian opinion, Gananian v. Wagstaff, both cited in our papers. I'd like to briefly address a couple of points that counsel made today. Counsel argued that this is not a right of action, it is a law enforcement action, I think referring to language in Ascanian. Ascanian certainly referred to a PAGA action as a law enforcement action, but it explained that that is true because it is brought not to remedy a private injury, but for traditional enforcement purposes such as deterrence or punishment. But there's nothing unusual about the legislature creating private actions for those purposes or to be brought in the public interest rather than to remedy a private injury. And we gave a list of them in our papers. Counsel also pointing to specific language in Article 5, Section 13, argued surprisingly that that section somehow requires the Attorney General to supervise, if I understood correctly, civil enforcement authority being exercised by other agencies, but that plainly is not the law. And again, we outlined cases in our papers where the Attorney General's traditional civil enforcement authority was completely given to another agency. That is certainly an untenable interpretation. And I'd like to briefly address, Your Honor asked a question about the relation between LWDA and the Attorney General. They're independent state agencies. LWDA is the state agency, the labor agency, essentially, and oversees various departments that govern various labor law issues, and the Attorney General is the state's chief law officer. They are independent. And the labor laws generally, it's worth noting, distinct from PAGA, vest the labor agency's primary authority for civil enforcement of the labor laws, not the Attorney General. The Attorney General and DAs prosecute misdemeanors and the like, but primary civil authority, enforcement authority, is given to the labor agencies. Finally, I'd like to briefly address Abbott. We addressed this at length in our papers, and I'd urge the court to review that. But Abbott rejected the precise argument that counsel is making here. The private drug companies had argued that essentially had made the same argument here about an alleged hierarchical structure for civil enforcement within California's Constitution, and the court squarely rejected that and ruled that there is no problem with kind of an overlapping scheme. It also, as counsel noted, referenced Article 5, Section 13, and that noted that under that provision, the Attorney General supervises DAs, but it did not remotely hold that that is constitutionally compelled for a private right of action. And again, Ascanian squarely ruled that it is not. Counsel astonishingly argued that the Attorney General made the opposite constitutional argument in the Abbott case, and I'm frankly surprised that counsel would say that. In that case, as the opinion itself expressly noted, the Attorney General did not join the constitutional arguments of the drug companies, and instead, as the opinion noted, the Attorney General weighed in with 3 practical considerations, as the court explained, in support of the statutory arguments of the drug companies.
Mr. Jones, are you basically asserting that Article 5, Section 13 is irrelevant to the issues here?
Yes, it is irrelevant to the separation of powers claim because that section is focused on criminal enforcement. Again, the Attorney General does have broad civil enforcement powers, but they are not among the core constitutional functions conferred by that provision, and they are not free of legislative restriction.
And you are rejecting counsel's argument that the Attorney General's position in Albert involved dishonesty and hypocrisy.
Absolutely. As I mentioned, counsel said that the Attorney General made the same constitutional argument with regard to Article 5, Section 13. That is patently not true. The Attorney General, that argument was made by the drug companies. The Attorney General, as the opinion itself notes, did not join that argument and instead made 3 practical observations in support of the statutory argument that was also before the court in regards to the interpretation of the unfair competition law, which has no bearing on this case whatsoever.
You have a minute left.
I think with that, Your Honors, unless there are questions, I would be happy to conclude with that.
I hear no questions. Thank you, counsel.
Thank you.
Mr. Fry, you have 2 minutes.
First, let's address Iskanian. Not one thing that's been discussed today was considered in Iskanian. County of Santa Clara, the main case it relies on is a judicial infringement case. It is not an executive branch infringement case. If you look at Iskanian, they don't quote one article from the executive branch. They don't discuss any of the issues about substantial control that would be required. Cases that don't consider certain propositions can't be cited for those propositions. That is a California Supreme Court statement in, ironically, a PAGA case, Kim versus Raines. So you can't use Iskanian to hold that they considered something that it doesn't speak, that it doesn't even discuss in the case.
But the same point applies to your citation of Albert, which was a case involving
Abbott, Yeah.
which was a case involving a district attorney. Trying to extrapolate from what they said about a district attorney to cases involving the public is a difficult thing.
I'm totally honest with you, it just shows that Abbott, which is a civil case, is using our Section 13 to describe the AG's powers and describing the AG as the chief law enforcement officer. That's the Supreme Court saying that in a civil context. By the way, the UCL civil penalties, PAGA civil penalties, they're identical in the enforcement. So I'm not saying that they found PAGA was unconstitutional. They didn't have to get to that question because they had public law enforcement officers that are clearly covered by Article 3, by Section 13. As long as, and they noted it, and they did so at the AG's request. And look, I'll be happy to send you guys a copy of the brief that was submitted to the appellate court in connection with that case. The AG has later removed its constitutional argument, I believe probably in response to this case, but they still, these 3 things they urged the court had to do with the AG's prerogative to tell the local DA to stay in the local DA's office and stop trying to interfere with California law.
You don't think they might have abandoned the position because they saw that it didn't hold up?
No, actually, they hadn't seen it yet. In the appellate court, the Abbott case is reversed.
No, I understand that, counsel. What I'm saying is, you're complaining that they changed their position from the appellate court to the Supreme Court. Right?
I'm saying that
You're
their
offering to
position in
send us
this
the
case,
brief to show us that they changed their position.
they changed their position in this case compared to that case. Both civil statutes, and one doesn't apply because somehow it doesn't apply to criminal, and another it does apply because they enjoy maybe participating in UCL actions. That's all I'm using it for. I apologize if I overstated dishonesty. That wasn't the intent. The intent is you can't have it both ways. And the California Supreme Court in the Abbott case states a core constitutional role in the context of a civil statute, the UCL, is that the AG is the chief law enforcement officer, and what saves that statute and that decision is because the AG retains its supervisory role. PAGA defeats that supervisory role. PAGA doesn't even allow the AG to review anything about the case that's being brought on behalf of the state.
We've used 3 of your 2 minutes.
I apologize.
No, there's no apology necessary, but I'm going to give you 1 minute to wrap up.
I just want to generally say that the cases that are alluded to as by Mr. Jones and his argument that somehow support that the executive branch power can be taken. Not one of those cases takes the executive branch power and removes it from the executive branch. They transfer the executive branch power from various branches to other branches. They do not take it outside. PAGA takes it not only outside, but hands it to a fourth branch, which shouldn't exist in California, private attorneys. That's the key issue in this case.
Thank you, counsel.
Thank you.
Mr. Jones, it does not help us to have you shaking your head in disagreement or nodding your head in agreement. We'll decide it on our own.
I apologize.
Thank you.